6, my lord, and there are 6 in the dock. May it please, my lord, my name is Timothy Amerit, Senior State Attorney in the Office of the Director of Public Prosecutions for the prosecution. The accused persons are in court. Mr. Kasolo, who represents himself, is in court. Then, Counsel Serwanga Joffrey, who represents A3, A5, A3 and A5 is also in court. Then Counsel Serwanga, my lord, Counsel Serwanga also represents A4, A3, A4, and A5. Counsel Serwanga Julius represents. Counsel Serwanga represents A3, A4, and A5.
My lord, PW4, Mr. Francis Anthony Luowa did not see the kidnap. Yes. Anthony Luowa, the father of Maria Nagrinya, did not see. My lord, the person who saw the kidnap, the alleged kidnap, was called Bena, who didn't give evidence in this court. My lord, who allegedly saw the kidnap was called Bena, who didn't give evidence in this court. My lord, PW9, Senabulia Isaac, who purported to give evidence in this court that there was any kidnap, told this court that he did not go to school, and that the car that was used in the kidnap was a Toyota Wish. Whereas in the charge sheet, the accused persons are indicted, and in the summary it states that the car was Toyota Spacio, white in color, registration number UBA 570V. My lord, registration number, my lord, registration number, it is UBA 570V. UBBA 570V. It is our conclusion, my lord, that there was not any kidnap. My lord, to prove the rest of the ingredients also of the offenses, my lord, there was no murder. And the cause of death of Maria Nagirinya and Chitayimbwa is not yet established. My lord, Dr. Moses Biaruhanga, a pathologist, gave evidence to the effect that PW1 gave evidence to the effect that Maria Nagirinya died from shock following blunt head trauma. PW2, Dr. William. Shock following blunt head trauma. PW2, Dr. William Male Mutumba, a pathologist, also gave evidence to the effect that Chitayimbwa Ronald died from injury due to blunt force trauma. Force trauma.
Force.
Yes, my lord. Injury due to blunt force trauma. But PW18, Mr. Onen Geoffrey, PW18, the DNA analyst, expert analyst, told this court that he found in his report the blood of the deceased Nagirinya on a panga. My lord, a panga is not a blunt object. And in light of the contradictions between the different experts, there is no conclusive evidence brought by the prosecution. There is no conclusive evidence of proof beyond reasonable doubt that Maria Nagirinya and Ronald Chitayimbwa were murdered. My lord, one of the ingredients of robbery is that there has to be theft. My lord, there was no theft in this case. In the charge sheet, my lord, it is indicated that one of the stolen items was motor vehicle, registration number UBA 570V, Spacio, white in color. My lord, this motor vehicle was never brought up in court for any identification, yet it was alleged in evidence that it was retrieved. No logbook of it was ever brought up in court to show that in Uganda there was such a motor vehicle. It is our submission that the pictures of the alleged motor vehicle were creations of Photoshop, and such a vehicle never existed in Uganda. And as such, creations of Photoshop and as such, a non-existing vehicle cannot be stolen. My Lord, A2 Rebecca Johnson did not participate in any of the alleged offenses, in the commission of any of the alleged offenses.
This is not evidence, it's submission. Still is required that they know what we are. Because the evidence bit is over.
My Lord,
We are counsel who deal with submission. But if you can, you will tell them, you can say,
the Panga, my Lord, because he did not participate, because the alleged Panga that was got from the pit latrine of his alleged residence was described as, I quote at page 16 of the submissions, I may not need to quote, my Lord. It was described as a crocodile machete. Machete. And yet, the DNA analysis report at page, described as PE22 at page 2, the DNA analysis that is described as PE22 at page 2, the alleged Panga is described differently. It is our submission, my Lord, that what was allegedly collected from the home of A2 is not what was submitted for DNA. And therefore, collected at the residence of A2 is materially different from what was submitted to DNA. Participation in this offense. For DNA analysis. Second reason as to why, my Lord, A2 didn't participate is in regards to the telephone of Chitaimbwa allegedly found with A2. The court did not see this telephone number, this telephone. It was not brought to court, my Lord. The serial number of the SIM card of Chitaimbwa was not mentioned before this honorable court. The exhibit storekeeper who was supposed to be in charge of this exhibit did not come to court to explain how he got the exhibit and how it disappeared. The investigating officer, PW21, Mr. Barasa T. James, did not tell this court, PW21, did not tell court that he called Sam or any of the numbers found in Chitaimbwa's phone, or any of the numbers in Chitaimbwa's phone, for people to confirm that indeed that number belonged to Chitaimbwa. My Lord, A2 further did not participate in any of the commission of these offenses because did not see the people who parked the motor vehicle at the alleged garage, PW6. This was the mechanic who was keeping the garage, so he could not have seen A2 at Mackay. At Mackay, my lord. Yes, my lord. My lord, PW7, Birungi Aisha. Birungi Aisha told court that fingerprints were taken of the motor vehicle, UBA 570B, but she did not bring to this honorable court any results from the government analytical lab to prove that the fingerprints of A2 were captured on the alleged motor vehicle. The fingerprints of A2, our submission that A2 did not have anything to do with this motor vehicle. My lord, A2 further did not participate in any of these offenses because of the camera evidence. My lord, PW19, Ogwang Nixon, told the court because of camera evidence. PW19, Ogwang Nixon, told the court that the camera was called Natete. Was called Natete. Yes, the name of the camera was Natete. And it was located in a community village trading center. My lord, the charge sheet states that the victims were kidnapped from Nabisasiro zone in Rubaga division. Nabisasiro zone in Rubaga division. Further, my lord, PW19 told court that from the footage, A2 cannot be identified. My lord, in relation to A2 and A6, the chain of evidence was broken. And we pray that our submissions at page 22 be followed up for that.
The chain of evidence
Was broken. And we pray that this honorable court takes note of our submissions on this subject at page 22 of our submissions. 22, my lord. Yes, my lord. My lord, the last element, the accused persons are not liable, is that the accomplice evidence of Senabulia Isaac lacked corroboration. And that he was drunk. He testified to this honorable court that he was drunk and sleepy. During his alleged witnessing of the offenses. My Lord, the scene of crimes reconstruction video also points to the effect that the accused persons were tortured. To the fact that the accused persons were tortured and they were coached on what to say. And that they had been taken to these scenes prior to the recording of the video. My Lord, PW 15. Nakatude Winfred. Sorry, my Lord, PW 17, Naiga Juliet. Naiga Juliet. Yes, Naiga Juliet produced a report PE 21. A report PE 21. 21, which was a translation of the reconstruction video, of the scene of crime reconstruction video. And at MOV 4 of that translation, and at MOV 4, V4, A2 clearly states that era nekululi nabaletawo abasirikale, which means, but last time I brought police officers here, which is evidence for the prosecution pointing to the fact that the scenes of crime reconstruction video was staged. My Lord, the conduct of My Lord, the conduct of the accused persons after the alleged offenses were committed is inconsistent with the conduct of guilty people. We rest our submission on that point with the conduct of a guilty accused person. My Lord, further explanations on that are at page 31 of our submissions. Yes, my Lord. My Lord, the participation of S6, Katerega Sadat. My Lord, S6 did not participate in any of the indicted offenses. PW 21, Barasati James. In his report, PE 24. PE 24. At page 7, he states that the telephone number of S6 was 07081 7081 90 11 2. Whereas when PW 21 read out the police statement of S6, which was dated on the 28th day of September, the police statement of A6, which was dated the 28th day of September 2019. The telephone number of A6 was 078 28th day of September 2019 was 078 555 3121, which is different. It's on all the investigations concerning searches and data analysis were in respect of a wrong number. The data analysis reports and the references to the joint communication chart were in respect of a wrong number. The joint communication chart were referring to a different number, which was registered in the names of a different person called Diana Nagwa. And not A6. No investigations were made up. Diana Nagwa, who was never investigated. For that reason, my lord, A6 didn't also participate in any of these offenses. My lord, it is our submissions that from the evidence of DW8, Ndoleyaho Teo. The plot to kill the deceased persons did not originate from prison. The motive to burn the police exhibits was not given in evidence. The police exhibits concerning the telephones was not brought up in evidence by the prosecution. The burning of the exhibits of the telephone of Chitayimbwa was not brought to the attention of this honorable court. And the rest of the unanswered questions in our submissions on page 30. We so pray.
Geoffrey for A3, A5, A4 and A5. My lord, we filed our written submission. We are just highlighting. Yes, and we are going to be brief in our submission. My lord. Yes, my lord. My lord, one of our submission, we listed the law, the particulars of the offense in this case, and the statement of the offense. But my lord, we also in agreement the law, particulars of the offenses, under page 1. My lord, we are in agreement with the prosecution that there was kidnap with intent to murder, and also there was murder with intent to murder, and there was aggravated robbery. and we submit that evidence was laid to that effect. However, my lord, our major contention in this case is the participation of A3, A4, and A5 in these 6 counts. My lord, I will first summarize the submission in respect of A3 and A5. Now, to prove the commission of the offense of A3 and A5, the state relied on the evidence of phone tracking and the evidence of video reconstruction scene and the eyewitness. My lord, A3 and A5 also gave sworn evidence which is on record. My lord, the summation of their evidence is the effect that A3 and A5 were innocent transporters. And their status as border, yes, and their status as border operators was not disputed in evidence. A person of the border stage, Makula stage, wrote a recommendation letter and himself came to court to verify the status of. Yes, ma'am. A recommendation letter and himself came to court to verify the status of A3 and A5 as border operators. My lord, it is not refuted in evidence that A3 and A5 transported Kasolo. Yes, my lord. Transported Kasolo Kopriam and others on that fateful day. However, my lord, as illustrated in our submission, there is no proof. My apologies, my lord. My lord, there is no proof of criminal intent in offering transportation services by A3 and A5. There was no proof that they were part of the plot or the planning of commission of this offense. And my lord, criminal intent is one of the elements of criminal liability. My lord, there was also evidence of video reconstruction scene, and we submit that this evidence should not be relied upon on account that it was obtained illegally and in violation of known principles of law, constitutional principles of law to that effect. My lord, in the video,
Hold on a bit. Oh, in violation of what?
of known principles of law, especially the principle of
Okay. We shall find out which
yes,
one.
as illustrated in my submission.
Mm.
And my lord, the video evidence was, there was no, in the opening remarks, in the opening video, there is no caution of the suspects featured in the video that what they would say would be used against them in court. And my lord, further the evidence of torture, which is verified by medical proof,
Yes.
also disqualify this video reconstruction scene as good evidence in this case. And my lord, in respect of murder and aggravated robbery, A3 and A4 were not at the criminal scene at all. They were not in the vehicle.
Yes, it is. Nani?
A5,
What about it?
even A4, my lord, they were not in the vehicle. They were at the various scenes of crime. They are not in the vehicle. They are not in the Namamve where the final execution was done.
At Muhulu or at Naman?
At
At Naman, so-
at Naman, my lord.
Oh, yes.
My lord, those are my lord, in respect of the phone tracking, which was presented live,
Yes, yes, it is. Yes.
my lord, we illustrated in our submission that the phone numbers which were tracked, first, were not even registered in the names of the accused persons. And the persons in whose names were these numbers registered were not investigated at all. And my lord, further, there was no also verification as to the communication, whether the communication between the owners of those numbers and Mr. Kasolo was in respect to
The owner,
of the numbers, the telephone numbers in question were in respect of commission of the offences before court. My Lord, in the end also we wish to submit in respect of F4. My Lord, F4 kept quiet during the trial. However, there is no, the only, yes. However, my Lord, there is only one witness throughout the entire trial who mentioned the names of F4, and that is PW21. In his evidence, PW21 testified that the role of F4, who is Chiseka Asa, was in respect of mobilization of transportation. First, my Lord, this aspect was not also proved sufficiently, and two, even if it was proved, there was no proof of criminal intent in mobilization of the transportation. There was no proof that F4 was part and parcel of the planning of these offenses. And my Lord, F4, there is no evidence that F4 Seka Hassan was part of the, was on the kidnapping scene at Longoja, that he was on the criminal scene in Longoja. No evidence showing that he was in the vehicle, and no evidence showing that he was in Mukono or Namanga. And there is also no communication that F4 communicated with any of the remaining accused persons during or after accused persons or after the commission of these offences. My Lord, we also illustrated the evidence of Senabulia, who was PW9. He properly stated the names of the persons he was with, and those names do not include the name of Chiseka Asa. My Lord, given that there is evidence of the eyewitness, who is Senabulia, and he exonerated Chiseka Hassan, and also further cement the role of F3 Chiseka, that is PW9, exonerate F4, and also exonerate F A5 and A6 to the effect their role was merely that of transportation. So, my Lord, we conclude our submission by asking court to acquit the accused persons A3, A4, and A5. And we also reiterate our submissions in the written form. So,
How many are they supposed to be?
6, my lord, and there are 6 in the dock. May it please, my lord, my name is Timothy Amerit, Senior State Attorney in the Office of the Director of Public Prosecutions for the prosecution. The accused persons are in court. Mr. Kasolo, who represents himself, is in court. Then, Counsel Serwanga Joffrey, who represents A3, A5, A3 and A5 is also in court. Then Counsel Serwanga, my Lord, Counsel Serwanga also represents A4, A3, A4, and A5. Counsel Serwanga Julius represents. Counsel Serwanga represents A3, A4, and A5. Man, I'm sorry about last week.